How about it?
Thank you, Wendy. Hello, everybody. My name's Joe Denina. I'm from member firm Russell Kennedy Lawyers, based in our Sydney office. Today I'll be discussing shareholder disputes and just effective strategies for prevention and resolution if your clients happen to find themselves in a shareholders dispute. So I guess the first thing I'll say is that unfortunately shareholder disputes are becoming quite common between shareholders, and they can happen for a number of reasons, including circumstances where the company's doing so well, shareholders arguing and blaming each other for the reasons the company might not be doing so well, just general sort of relationship breakdowns between shareholders, which can often involve family members, it can involve friends, just pure business partners, or even people in a personal relationship together. So I guess once you find yourself in a dispute, it's really important that the shareholders understand their rights and options about what they can then do once they're in a dispute, what they can do to resolve that. So just broadly speaking, because I know we're a bit short of time today, we've got some presentations to get through. So broadly speaking, I'll just cover off on sort of 4 options once a shareholder dispute does commence. So I guess the first one is to sell your shares or buy out other shareholders' shares. And I'll touch on things that you'll need to do if that's the option that you're looking at taking up, to negotiate your way out of the dispute by sitting down and discussing things and trying to work out a resolution. If the company's not performing so well financially, an option may be voluntary administration, where the shareholders might voluntarily look to put the company into administration and put it into the control of an administrator. And then, of course, if you can't resolve it any other way, you may look to court involvement for resolution. So with respect to selling and buying out shares, it may be an option to buy another shareholder's shares in circumstances where 2 shareholders cannot get along, or there's going to be the entry of an outside shareholder. But one really important thing, if you're going down the road of selling or buying out of shares, is that a proper valuation is undertaken, because you want to make sure that there's a fair deal in it for everybody, at least your client, the person that you're representing. So it's very important to undertake a proper valuation of the company, which may involve some forensic accounting to go into the books and the records of the company, just to make sure, as I say, there is a fair deal for everybody. Of course, some negotiation may be the cheapest option, negotiation and resolution. And this is where having an effective shareholders agreement at the outset is one of the most important things you can do. A shareholders agreement that outlines what may happen in circumstances where there's a shareholders dispute, a particular regime that the shareholders must follow if a dispute arises. Things like compulsory mediation and attendance in front of a mediator to resolve your differences. And a lot of the time that can effectively resolve the differences when people have had the opportunity to discuss them with an outside party, a neutral party. So with respect to voluntary administration, it's probably the most common option people may take in circumstances where the company's not performing so well financially. If it's insolvent or as I say, just struggling to meet its day-to-day expenses. Now, with the appointment of an administrator, that may also follow then the appointment of a receiver or manager, or the administrator might what they call a deed of company arrangement, where they can set up particular methods by which the company will be run to manage itself, if it can be, out of the crisis that it's in. And then finally, again, as a last resort only, because it will be the most expensive and most serious resort, is court involvement. In Australia, we have a particular regime under the Corporations Act, which is federal legislation. I'm sure there's similar types of legislation all around the world. But in Australia, there's three main sections of the corporations legislation when it comes to shareholders' disputes. There's sections 232 and 233, which work side by side. 232 sets out what oppressive conduct is and allows the court to take into account whether certain things that the court considers are oppressive, maybe ousting by a particular shareholder against another one, or two against one, majority shareholders against minority shareholders. If the court finds that there has been oppressive conduct, then it can then shift its focus to section 233, which outlines the relief that it can provide.
Joe, 1 minute.
Yes, thank you, Wendy. Which can include winding up the company. It can order that certain shareholders do or are refrained from doing certain things, and it may even order the company to institute, prosecute, or defend proceedings against it. So, and then the last and I guess final most serious resort is the court has powers under a section 461 to wind the company up itself. The court will order the winding up of the company in circumstances where the relationship just cannot go any further. So I guess in summary, the first most important thing to have in place is a properly drafted shareholders agreement that puts within it a certain regime that the shareholders must adhere to should a shareholder dispute arise.